Hi, my name is Carl Birkhead. I'm an attorney with Wirth Law Office in Tulsa, Oklahoma. I'd like to talk to you a little bit about tribal jurisdiction and how it plays with criminal cases that are filed within the state of Oklahoma. I'm talking to you about this because recently the Department of Justice has actually taken two different district attorneys, one from Rogers County and one from Okmulgee County, and filed a lawsuit against them for improperly filing charges against individuals that should have been tried in either federal or tribal court. So I want to talk a little bit about when jurisdiction goes from the state to the tribal court or federal court for that matter, and how that might apply to you. So basically, this all comes down to a case that was decided a couple years ago called the McGirt case. You may have heard about it, you may not have, and I'm going to give you just a very broad stroke of what it was about. Essentially, an individual who is of Native American descent and an enrolled member of a Native American tribe committed a crime on tribal land, or allegedly committed a crime on tribal land. And so the state filed charges and pressed charges against him, went through the entire system, was convicted, sentenced to a term in prison, and it got appealed based on the argument that the state did not have jurisdiction to prosecute him because he was a Native American citizen. And it went all the way up to the Supreme Court. And the state of Oklahoma's argument was essentially, hey, so we understand that under federal law, we shouldn't have necessarily done this, but this is how we've always done it. So let us keep doing it. And the court said no. Um, basically, the court ruled that any crimes committed by a Native American person on tribal land, they can only be prosecuted by either the feds or by tribal court for whichever tribe the crime was committed in. And that's obviously it's caused a lot of confusion, a lot of uh, I don't want to say frustration, but it's shaken things up a lot as far in our criminal justice system. And for us defense attorneys, it has caused a lot of confusion and caused a lot of us to have to educate ourselves about when and how these tribes can be prosecuted by the state versus by the feds or by tribal courts. So all of that to say, if you find yourself in a situation where you are enrolled or eligible for enrollment in a Native American tribe and you're being charged with a crime, it's absolutely worth it. And quite frankly, it's essential that you make sure that the state has jurisdiction to charge you for that crime. Um, the state Supreme Court has interpreted the McGirt ruling since then, and there's been some direction that's come out that's kind of helped prosecutors and defense attorneys figure out exactly how to do this and how to work within this new system. And clearly, the federal government thinks that certain prosecutors within the state have gone past what they're supposed to be doing. I'm not here to say whether or not they have or have not. I'm just here to simply say, if you believe that you're being charged with a crime that the state doesn't have jurisdiction to charge you with, absolutely give our office a call. I'll sit down with you, we'll go over the facts of your case, and we'll figure out if lack of jurisdiction is a feasible defense that you can raise. My name is Carl Birkhead. I'm with Wirth Law Office, and I want to help you make law easy.